Okay, let's settle in so we can get this going.
Grab that sheet. I don't think anyone's signing up.
Hey, we have a sign-up sheet. If you don't see it, it's because we're looking for it.
No, that's right. It's
Okay,
at the front table.
so we have a sign-up sheet on the front table if you're interested in speaking to the bill. And this is the only bill we're going to hear. And Vanessa, since you're listening, if you could find us a room upon adjournment tomorrow for 5 minutes, I'll have you out before lunch. That was for Vanessa. Because, I mean, 1:05. We'll be out in 5 minutes. I'm sorry, upon adjournment. Okay, so before we get started, Chairman Petrie, you want to open this with prayer? What's your mic number?
Glad to do that, Mr. Chairman. I'm 23.
Okay, go ahead.
Dear Heavenly Father, we ask that you would bless all of us in this room, help us to make wise decisions, to use good judgment, to do what is best for the people of Georgia and for you. In the name of our beloved Savior, Jesus Christ, amen.
Amen. Thank you. Today we have a combination bill. I'll let Bob do the honors. So we're going to do this a little different instead of the author explain the bill, since this did go to advisory council, the meretricious part, and then the other part is the TTD that we discuss either every year or every couple of years. So with that, all right, let me explain this. So this bill I was going to do it, and then Representative Lehman is going to carry it. So we have an LC number. He's got a bill. If you would like to sign it, he's going to drop it, and it's going to be first read tomorrow. But we're going to do all the discussion today, and then if we can get a room upon adjournment tomorrow, we will, as soon as you get there, make a motion second and pass it out. Assuming all of you like it, but just want to try to get ahead of, because of the new folks, if you haven't seen it, even though we've only been having 2 or 3 bills each day, the doors of the avalanche are about to open. And as you've already heard this morning, half the bills that you will hear will be introduced. Well, it passed the House and didn't make it through the Senate because of time, so we want to get ahead of that. So that's the posture we're in. So Mr. Potter, go ahead. Where's the table? Okay.
Let me just take it from there. Okay. So thank you, Mr. Chairman. Let me start with this. Last year in this committee, you all referred really 3 items to the Advisory Council to review. It was. Sorry. So thank you. Thank you. I should start. I'll start over. So Bobby Potter, and I'm here really on behalf of the Advisory Council, which is, for the new folks here, it's a group of about 100 folks that Chairman Ben Vinson appoints to, and Chairman Ben Vinson is the chairman of the State Board of Workers' Compensation, sitting behind me. He and his predecessors have appointed this group through the years. Comes from all components of the workers' compensation system. They meet and try to help solve some issues, tweak some things in the workers' compensation system to allow it to run better, and it has worked extremely well over time, over the last 25 or 30 years, to avoid knockdown dragouts in part here on other issues. But they have a rules committee that revises the rules from time to time, a medical committee that deals with that aspect, and some of that is to keep all of that off of your plate. So a couple of years ago, Chairman Vinson had asked me to chair that advisory council. I've been the chairman of the legislative committee since I can remember anyway, so I've been on there for a long time, and have practiced in this world as a lawyer for 45 years on the defense side. I am often down here, actually every day down here, on behalf of State Farm Insurance Company, who I represent as a lobbyist, and the American Council of Life Insurers. They don't have anything to do with this discussion here today. While State Farm writes some workers' compensation, it's as an accommodation. They're really not engaged in this. I'm here speaking just because of that background that I've given you all. So, Mr. Chairman, that's the background. So let me pick up with where I was. Last year, you all suggested that we take a look at Representative Moore's bill that had to do with termination of dependency benefits in a death case. Secondly, you've talked about indexing a ton, and that refers to the maximum compensation rate. We have discussed that. And the third item is PTSD. So I'll give you a quick update on each of those. So then get into what is LC 365484. So the conversation in the advisory council, let me just do this backwards in regard to PTSD, I could say this fairly quickly. That arose in this committee last year with Representative Kennard's bill. It is and was a good idea, but under the workers' compensation world, it was fairly problematic. You all had looked at a firefighter concept 2, 3, 4 years ago. We have adopted that concept. The cities, counties, the state, and the first responders have been meeting for months on that, and they're very close to an agreement to make that work in that fashion. Representative Devin Seaball does have or will have a bill. It's hard to tell the League Council right now as to where that is, whether it's out or not, I'm not sure. But that is coming to address that issue. So that will be, that's a standalone. That may come to this committee. It may come to insurance. I'm not sure of that. So that's the nature of the PTSD bill. I would tell you that I think all of the parties engaged in that seem to be pretty much on the same page. They may have some disagreement about a word or two. And the other two items are reflected in some fashion in LC 365484. So let me just move to that. And I would tell you that this part has been fluid since the advisory council met off-site at Jekyll in the fall. I asked a subcommittee to look at this. They have been looking at this, lots of conversation, lots of Zoom calls. After one of those Zoom calls, the claimant lawyers have to go back and have their own Zoom call and talk. Instead of 3 people, they talk to whatever, 12 or 13 or 14. On the employer side, they likewise flesh out kind of what's happening and where that stands, more from a conceptual standpoint. But it has been fluid up to probably literally about 10 minutes ago. And there are a lot of hands in that pie. So this is what I would hope to be a final version. It's always hard to use the term final, but that's what this product is. And right before I get into the balance of that, I would like to publicly thank Rebecca Hallberg, Jason Perkins, Josh Carroll, and Mike Bagley, who with me worked on a bunch of Zoom calls to get to this point. Lord knows how many drafts there were even before an LC number, but there's been 4 of those since an LC number. So a lot of give and take. There's some folks on one side that aren't totally embracing this. Surprise, surprise. There's some folks on the other side that would feel the same way, but this appears to be a good package compromise. So the bill in front of you, LC 365484, the second page of that is existing law. This has to do with the dependency statute that arises when there's a death on the job that is compensable. An employee has died. The first part of this language is not changed. That's where there's a parent. There is a spouse or a child under the age of 18. That person is conclusively presumed to be a dependent. That is, there needs to be no proof of.
It's actually just, we need to change it to LC 365495.
Isn't that special? Okay. So apparently it is LC 365495.
Well, but for clarification, the one you have in front of you is the one he mentioned. The one we will vote on is the second number. They are word for word. There's been no changes, okay? So just so you know, if we can get a room tomorrow and vote the bill out, you don't have to trust me. You can hold it up to a light. But anyway, go ahead. Those are two LC numbers, and they're exactly alike.
I'll go with that. So let me pick back up at the top of this page. That deals with conclusive presumptions. There's no need to prove dependency. That category is conclusively presumed. So no changes there in line 16 through 19 up in there. At the bottom of 2, at least on the draft I'm looking at, is line 40. There's some new language. Does that make sense? Thank you. So the law had been, after these conclusive presumptions, in all other cases there could be factual dependency proven. That remains the case. There's some clarification in that paragraph, and I'll just walk through that. The first part of that would say, in all other cases, including where the deceased employee and a claimant dependent live together continuously and openly in a relationship similar akin to marriage, there shall be no presumption of dependency. So if there's not a ceremonial marriage, there is no presumption of dependency. That clarifies that. But if there's no ceremonial marriage, and this is where it would pick up, and a claimant dependent's dependency in whole or in part shall be determined in accordance with the facts at the time of the accident. That allows for a non-ceremonial, folks that are in a non-ceremonial relationship to prove some actual dependency. And then the next language in 44 through 46 gives a bit of a roadmap about how that's done, based upon evidence proving the deceased employee provided supportive economic value to the claimant dependent, including but not limited to monetary support, sustenance, or housing. So that's what that is all about. It clarifies that if not a ceremonial marriage, there is no conclusive presumption, but that relationship could be entitled or at least eligible to benefits if they can prove dependency. And that proof is in that roadmap of 44 through 46. Longstanding in the statute has been that next line, and it's just changed a little bit just because of the way the sentence words, but it now reads, no consideration shall be made for any payment exclusively for board and lodging. That has been in the law forever. It just had to change a little bit just because of the change of the phrasing above. And the other aspect I would say to that, just from a clarity standpoint, there is a Supreme Court case 20 years ago that said, if not ceremonially married, there is no entitlement to benefits. This addresses that and changes that and allows where there's an injury on the job and somebody's lived together for 20 years, which was the case then, that could be deemed to be a factual dependent. In that case, there was discussion of this eloquently stated by Justice Weltner at that time, that the claimant is a factual dependent. Dependents are entitled to benefits. The claimant ought to be entitled to benefits. That's kind of what this is, if they can prove that under that circumstance. So that's what that is. And then in subsection E, that's the termination of benefits. So somebody has died, there's benefits, the benefits have been paid for a month or 5 years. If that person who is receiving the benefits based on the death of an employee remarries, that's at line 55, then benefits cease if they're remarried, the presumption being that they're now no longer dependent. The rest of that is mirror image to the entitlement in D. That is, if one enters into a relationship that includes the support of economic value to the claimant dependent, including but not limited to, all those words that included the entitlement above, if you enter into that type of relationship, then benefits can be suspended. They can't be suspended unilaterally. It would have to be upon determination by the board, which is in line 55. So it would be the same kind of factual determination as we have talked about this on the front end, entitlement to benefits, and on the back end, suspension of benefits. if that same circumstance arises. And the last line I would mention there, line 61 and 62, it would need to be a relationship that exists for some period of time, and here it is at least 3 months. So that is the nature of that, and that's what that portion is. I'll move on and finish the rest of this.
Yeah, let's take a pause there, because I know there's a lot of legalese, and we may have to come back with some examples or stuff. Let's address this part of the bill. Okay, 23, Chairman Petrie.
Thank you, Chairman. All right, so I'm trying to get caught up on this quickly, newly being on this committee. Glad to be on here, though, Chairman. I've been a large employer for my whole career. So I understand the expansion, the new allowance here.
Yes, sir.
Okay, which I think is a good thing. But I have one problem with it as I read it, and you help me to understand. 3 months. So if indeed there is no ceremonial marriage, and someone has a right to still prove that there's a relationship that would make them a warranted dependent, it seems to me that it's tough to do that with a 3 months relationship. Am I wrong? I mean, so if you've been living with somebody for 10 years and there's no ceremonial marriage, and you've had a relationship that certainly involves support and all those things you have, that's easier to determine. But is 3 months enough time?
So 3 months, it may be enough time. It may not be. That would be a determination made by the board under a factual circumstance. But the 3 month here on line 48 has been in the law for an awful long time.
It has been, but but you're changing it now.
We are.
You're expanding it now. So it's been there. That's my question to you, sir. So the 3 months has been there, but it's been there in an arrangement that you described earlier and was tested by the court, where it was only those with ceremonial marriage generally. So
That is
now that
accurate.
you're expanding it, should you not consider changing that timeline? That's my question. Because 3 months is not a long time.
3 months, it may not be a long time. I think it would be up to the board. We paired it with a 3 months on the back end.
Okay.
I understand the.
That's my question.
I understand the question. I
That's
think
my
it's
question.
it's a valid observation. Could be longer, could be less, but I think when we entered into this conversation, part of what I try to do is change as few things as possible in existing statute that has been determined before. I get it that you said you're changing this part and broadening it on the front end. Should you look at this? Honestly, we matched the back end with the front instead of expanding that in one way. From a dartboard standpoint, you could pick it further. Yes, sir.
Representative Parks.
Thank you, Mr. Chairman. Mr. Potter, always appreciate your presentation. Is it not true that the burden of the rebuttable presumption is on the claimant to prove that relationship of dependency existed?
So, in this case, there's no rebuttable presumption. It's an unusual part of the law, but in the first part that we did not change at all, there is a conclusive presumption. Presumption is probably not even the right word, but if you're a spouse in a ceremonial marriage or a child under 18, you are conclusively presumed. The employer could not rebut that and say, well, I don't think you are because you just won the lottery last week. It wouldn't matter.
Just to clarify, on line 42 where it says that there shall be no presumption of dependency, it would ultimately be up to the claimant to prove otherwise.
Yes, sir. That is correct.
And is it not further true that it would be the totality of the circumstances taken into consideration along with the period of time that the board would consider as to whether or not that relationship of dependency exists?
It would.
Thank you.
Yes, sir. Thank you.
Chairman Carpenter.
Thank you so much. Just give me a little bit of clarification on the back end piece we're talking about. So this clearly is not lump sum payments.
It is not.
It is not. This is set out over a period of time, and you're just saying, if you get into another relationship and 90 days in, just like on the other side, if you go find a new fella or lady to live with 90 days later, then you could lose those benefits as well. And I assume that was part of the negotiation to give the front side up to the same relationship. Is that a fair assumption?
Yes, sir, it is.
Okay. Whew. See what else I had. Sorry, I apologize. And then I guess the other question would be, doesn't necessarily mean they haven't been in a relationship for longer than 90 days. It just means that either he or she's been living with the spouse for the 90 days. So they could be in a 6-month relationship. It only became a kind of a dependency relationship for the 90 days prior.
It
Does that
could.
make sense? Is that fair?
Yes, sir.
Representative Park?
One more question, if I may. Mr. Chairman, thank you. When it comes to the determination by the board, is that, can that be repealed? Is there an opportunity, to say the board got it wrong for the claimant? Could you provide additional information as to what additional due process rights there may be, if any?
It can be. Any determination by the board can be appealed, and it could be appealed either way.
Thank you.
Yes, sir. The other comment I would make just about the 90 days, just because we've had discussion about that. The other, the part that also was not changed, back at the front at line 23, on the conclusive presumption, this legislature moved that 90 days, I don't know, some years ago, maybe 10, maybe 15, where there is the conclusive presumption or a wife or a husband, except if the wife or husband were living separately for a period of 90 days immediately preceding the accident which resulted in the death. So there could be questions raised at that point. And in all honesty, I would tell you, I don't remember our picking up that one from the other 90 days, but there is some consistency there.
Chairman Bonner? You on 29? Nope. Try it. Grab Lisa's. 28.
There you go. And I'm sorry, is this 90 consecutive days?
I'm not even sure how to answer that.
Well, I mean, it does say 90 days prior, but,
Where are you?
well, I guess line 48, I see dependency existed for a period of 3 months or more prior to the accident. So
that part has been in the law for a long time, and it would be the determination of the board as to whether that's 3 months consistently. But I think they would read it that way, as opposed to an on and off relationship, 1 month here, 1 month there, if that's what you're asking.
well, I guess I'm just looking for some clarity on how it is viewed, because what we are saying is in this expansion is that it seems as though we're almost giving more discretion to the board in my mind, and so I'd like just a little clarity on is it 90 consecutive days, or is it even are they limited to just a period of time, but they can only hone in on 90 days? I mean, it does raise a few questions in my mind as to how it's actually evaluated.
So my gut reaction take is it reads 90 days or more, so it would be looking at least a minimum of 90 days. I think the board would read that consistently as a running calendar of 90 days. Not 10 days here, let's take a month off, let's come back. It would be at least 90 days. And what they would be looking at is a relationship similar or akin to marriage. That's what it's trying to define.
Gotcha. Thank you.
Yes,
And
sir.
it's a great question. And the judge who would be handling the case at the highest level was nodding his head. Well, I was going to say he can answer it later, but he's going to answer your question right now.
I'll do either way you want me to.
No, go-
I can answer it later. I can do it now.
Go ahead.
All right. Thank you, Mr. Chairman. Ben Vinson. I'm the chairman and chief appellate judge of the State Board of Workers' Compensation. Been on the board since 2017 and became the chairman in 2021. So for the new members that I hadn't met yet or talked to you in a meeting yet, welcome, and I look forward to working with you. Please reach out to me if you have any questions. Great discussion so far. Thank you, Bobby. Worked closely with Bobby on our advisory council, and I'm happy to talk later maybe about how the advisory council works and just reinforce what's gone on so far with this piece of legislation and others. The 90 days, the way to look at it, it's a 3-month. A lot of times in workers' comp, it's the date of accident is the date that matters. So really what you're doing is just a halo period, either before the accident, 3 months, or after when someone might be trying to cut off someone. So really it's on the front end part that we've been talking about. The reason you want to look at 3 months is because you don't want somebody to either go in with somebody and try to claim dependency if they've only been living with them for 1 day. You want it to be a longer period of time so that you can say that's a continuous and open relationship. That's how a judge, when the facts are in front of us, the judge will look and they'll say, wow, they were only together, and like 1 day is not enough. But if you're actually together for several years, so really it's just the 3 months is just, it's a halo, it's enough. And then on the back end, same way. On the back end, you might not want to go in and try to cut somebody off if they go in and start living with somebody for 3 days. You want to see it go on for about 3 months. And that would determine if there's actually a relationship there, something that's akin to marriage. So that's kind of the 90 days.
That's a great answer. And that, you know, back to Petrie's original question about is it enough? Because if you change on the front end, you got to look at the back end. But that's, I mean, it was, every word of this bill was discussed ad nauseum. So I will not be accepting any amendments, just to let you know. Who's Chairman Jones?
Thank you. Judge, could I ask just a really quick question? I'm just intellectually curious on something. On line, and now I've lost it. Hold on just 1 second.
Sure.
Here we go. Line 22 and 23. I know that's not being changed, so again, just take 1 minute, please. I don't want to take Chairman Werkheiser's time, but except that if the wife and husband were living separately for a period of 90 days, I have constituents who are expats who the husband goes to Hong Kong for 6 months or the husband goes to an oil platform for 6 months. When you're sitting in judgment of these type of cases, is that the type of information that you are talking about when you answered Chairman Bonner's question?
Absolutely. You're going to be able to look at the facts of each individual case. So if it's rebuttable, that would be a good way to rebut it.
Okay, all right,
Yep.
thank you.
Mhm.
That's a great example. Expat. Representative McLean. Nope. Representative Park. Third tries a charm. Representative Holly.
All right, thank you, Mr. Chairman. Let's all partake in some musical chairs. Listen, thank you, Mr. Potter, for coming. And I think, you know, hearing both sides here, and I think this, I read it, seems very clear. Just to assure us that the Workers' Compensation Board is not just a bunch of crackpots who just kind of get together and just make up funny things, and you all are trusted. If you could provide colleagues who are not too sure about what this bill actually provides, what in the space of evidence do you determine to be legitimate in order to consider this 3 months, so that we know this 3 months is not just some, you know, it's not 5 days in a bed? What do you actually look at? And maybe, Judge, if you wouldn't mind, be able to share in terms of what actually solidifies this 3 months to actually make it a relationship based upon the evidence that's provided.
You want that one?
Yeah, thanks, Bobby. So, and we had a case where we had to analyze this a little over a year ago. An employer sure was moving to cut off benefits of a widow. And so our ALJ took a lot of evidence in and analyzed. Sorry.
Pull that mic up or
Yep,
either
sorry.
get a little closer.
There you go. Our ALJ analyzed the facts and then ruled in favor of the claimant, so did not let the widow be cut off. And we upheld that. And that's kind of part of what sparked a little bit of this discussion, I think. So you'd look at, I mean, and actually in the bill, it mentions a few things you might look at, like monetary support, sustenance, housing. So you're going to go in and you're going to analyze what's going on in that relationship and what things are being provided back and forth between the spouses, who's paying for what, do they own the home, do they rent the home? For instance, a big fact that might be, if you're talking about two people and you're trying to prove if they are living together openly and continuously, do both people maintain separate residences? Does one person actually have an apartment and do they live a few hours away? that would be a fact you'd want to look at. So that's a lot, kind of anything, and then the judge will weigh it all. Yeah.
Yeah, thank you.
Thank you.
You've answered it. Yeah, I just wanted to make sure that we're not talking about people who are trying to hurry up and move in so they can get benefits. You know, you all are wise enough to be able to see right through that, right? Okay, thank you.
Anybody else? Before we go to our speakers.
So-
Go ahead.
So I need to finish the rest.
Oh, yeah,
of
let's go to the other part of the
rest
bill.
this So to conclude that question, that roadmap that is laid out is in lines 45 and 46. Some of the characteristics that they would review is economic value to the claimant dependent, including but not limited to monetary support, sustenance, or housing. And truly, you could list 100 further things. It didn't seem wise to do that in terms of other things. So before that, it did not have a roadmap. It just said will be determined with the facts at the time of the accident. That was it. So this gives the board, along with case law, some guidance from that perspective. So that is that. Section 2 deals with moving the maximum rate from $725 on line 74 to $800. That is the maximum. When an employee is injured on the job, he or she is paid 2/3 of their average weekly wage up to this maximum. And the maximum applies to, what was it, about 25% of the cases? 30% of the cases. So the vast majority are below that. Section 3 deals with temporary partial disability when the employee is able to return to work but not at full duty. It can be working some and receive temporary partial disability. That maximum moves up to $533. That's really a formula. When the TTD in line 74 moves up, the TPD moves up at 2/3 of that rate. So that's what that math is. It's simply 2/3 of the 800. That is section 3. Section 4 at line 99, that's the only change. That moves 290,000 to 320,000. That is the maximum in a death case for a sole dependent that doesn't have another dependent within a year. And that's pure math as well. That's the new $800 rate times 400 weeks. That's not paid out lump sum. It could be, but that is the maximum. So it's in a typical case, it's paid out by the week. Now, lots of those cases might be settled over time, but the entitlement is to be paid out by the week, hence where there could be a termination of that dependency entitlement. So that is that's the nature of the bill.
Representative Park.
Thank you, Mr. Chairman. So just as to the amounts, I'm assuming that these are compromise amounts approved by the advisory council?
Yes, sir. Excellent question, and I left one part out because I said I would speak to indexing. And you all had thorough discussion about indexing last year. You asked us to look at that as well. In the legislative committee of the advisory council, I've been dealing with for a long time. I asked all of those folks that participated, including those names I mentioned earlier and everybody else in the room, do you want to engage in this discussion about indexing, which will include, by necessity, a discussion about suspension of benefits based on maximum medical improvement, on the front end of benefits, whether it's by dominant cause or not, and subrogation. Those are items that are in other states that have indexing that we do not have. So it's, as I talked about it last year, it's easy to isolate something and say, let's just talk about indexing. But the political truth is, if you do that, you talk about all these other items. Nobody, including all of the claimant representatives in the room, really wanted to go down that path. So then we looked at the number, and it was the pure math, and it got us around the $800 number. Actually, it may be slightly more than that, but through the years we've hit on either 25 or a 50 or around $100 number, and that's where this has ended up. There may be a need to change that again next year. We would review that in October and come back to you again, but that's how that worked. The number was 800. There was lower numbers that were shopped around. There was some discussion about higher number, but this is about right. And yes, that was approved by the advisory council and by the board.
Thank you.
Representative McLean?
Thank you, Mr. You get me?
Yep.
Thank you, Mr. Chairman, and thank you, Mr. Potter, too, for always, I guess, talking and telling us the truth about where we are. I guess, is this a national average? I know that you were talking about indexing, but I was just wondering if we ever thought about cost of living adjustment. And I'm just trying to, just to make sure that, you know, instead of being stuck in the 21st century, we can move to the 22nd or 23rd.
Yes, sir. So here's how I can respond to that. The advisory council and the board in that sense tries to stay close to 2/3 of the statewide average weekly wage as reported by the Department of Labor. And that's the number that we look at to do this calculation. It has nothing to do with the national average. It's state-based. From a national standpoint, we are lower than a lot of states. There are a lot of states that are much higher, but they have other parts of their workers' compensation system that are quite different. Their benefits may not last as long as they do in Georgia. They may have higher benefits, but they suspend them much quicker automatically, like maximum medical improvement. So there's balance in each of those. But to directly answer your question, it's tied to, the aspiration is tied to the Department of Labor's numbers on statewide average weekly wage.
Thank you. And the cost of living adjustment is just something that has never been, you know, I'm just trying to make sure that sometimes we can take things out of our hands and it does what it does by cost of living, you know, by adjusting whatever we adjusted by.
In terms of this number, that's what we look at as the Department of Labor numbers and not cost of living. They may look at cost of living in terms of how that is done and how it's calculated in various industries, but we rely on the Department of Labor numbers.
Thank you.
Yes, sir.
That is all of the questions. Had a couple people sign up. Did we have that list up, or do you have it? Tell us who's on the list. Is anybody on the list?
There's no one on the list, Mr. Chairman.
Okay, but we have a couple people. I'm going to call on Sarah Stottlemyre to come up. She is a representative of WCCL. Rebecca, are you going to speak or just Sarah? Okay. Who are you?
My name is Sarah Stottlemyre. I'm actually the president of the Workers' Comp Claimants Lawyers Attorney Bar for the Georgia Trial Lawyers Association. I've been practicing workers' comp both on the defense and the claimant side for about 17 years. I'm Rebecca Hallberg's law partner, who is on the Legislative Advisory Council, and also Todd Majors in my office, who is the chairman of the Rules Committee for the Advisory Council. So I am intimately involved kind of in all of the workings as far as getting compromises on these bills. I would just like to say that much as it is when I mediate a case, I mediate also part-time for Bay Mediation. I think the sign of a successful mediation is when nobody actually leaves the mediation happy. Somebody pays more than they want to pay, and somebody receives less than they were hoping for. I can promise you with all veracity that this has been probably over 1,000 collective attorney hours working on this dependency bill, where we have groups on both sides that are more outliers that will have, you know, which are significant concerns, but we have to come to some sort of compromise. So speaking on behalf of the claimants bar, while we ended up with maybe less than we would have liked, I can promise you that the defense bar ended up giving more than they had liked.
And when you say claimants, just because a lot of us, maybe might not know a claimant defendant.
Okay.
But we
So
might know employer, employee.
Employer, employee. I represent employees, and I am the president of the Injured Workers Attorney Bar, where Bobby handles the defense side. So there has been significant amount of compromises and hours put into this, down to simple minutia of a semicolon and where it may go, and individual words that would be placed, 1 or 2, and then we would go back and have a Zoom call for another 2.5, 3 hours with 14 people. So none of this was taken lightly by either side, and I believe that it does represent a strong compromise on both sides, so that I will not be here tomorrow because I'm flying to Keystone to go skiing. But I would ask that you all please vote in favor of this bill. So.
All right. Thank you, Sarah, and I do appreciate the many hours. I was only a small section of those hours emailing attorneys during the Super Bowl, and that was just only a couple of days ago. It's been a lot of hours, and I appreciate, and also you, Rebecca, Bobby, and he's listed a lot of other people. Anybody else before we finish with the chairman? Okay, come on up.
Thank you, Mr. Chairman. Again, I'm Ben Vinson, Chairman and Chief Appellate Judge of the State Board of Workers' Compensation. And I just want to, I'll ask you to support this version of the bill. It's 36, 54, 84, or 95. It's the version that we've been looking at. And I do want to just echo a few things. I want to thank Representative Franklin for stepping up and helping us out. I look forward to working with you. And I want to thank Bobby Potter for his leadership on Advisory Council. And I do want to just let you know, you've heard a little bit about the process. You talk about what might go on in Judiciary Committee with those lawyers down there arguing about stuff. Take a workers' comp bill and put it in front of, a dozen workers' comp lawyers. It's exhausting, and I thank them for it. There's a lot of hours that went into this. So, and I agree, it's a compromise, and that's part of my role as the chairman is to use the Advisory Council and the advice I get from them, and then looking back to other people that I know in the workers' comp sector who actually either employ people or are employees or represent employees, and make sure that what we're trying to get is balance. So I think in both parts of this bill, you're trying to achieve balance. And so I'm happy to kind of work with you afterwards and answer any more questions you might have. I think Bobby did a great job walking you through the different provisions. And again, I'll ask you to support it. I'm happy to really give you more insight if you want to know it about each provision, how we got to it. But it's a process. We try every year to handle workers' comp issues amongst the people that do it all the time, and then try to come to you and present a united front. So I think so far what I've seen is pretty good on this one. And I've had a lot of conversations leading into this meeting. One thing I did want to say about the drafts and the things that are floating around, that is because of all the work that was being done. So we started at the end of the meeting last year, took the issue, looking at the back end. By the time we studied it, we were looking at the front end. A lot of people were working on it, and then you're going back and forth with drafts and trying to get the language right. So that's kind of how we are where we are today. I'm happy to answer any questions, and other than that, I would ask you to support it and ask you to work with us going forward.
Any questions? Which brings me to another thank you. Thank you, Sean Marie Story. I get a lot of emails from her at 6 o'clock in the morning, and then, or 11 o'clock at night, midnight, and then 6 o'clock the next morning. So I think I got 3 drafts from you in about a 6-hour period. So thank you for all your efforts as always. So here's our posture. We can't vote, so we're going to do a first read on the bill at 1 o'clock tomorrow. And he'll make a motion if going to the clerk. So if you want to sign on to the bill, see him before he heads across the street. We will meet at 2:30, because that's about the time the session is going to end, in this room. And I promise you, there's nobody who wants to be in South Georgia faster than you, unless Sarah has a cancellation. I'm open for skiing. Other than that, I am very anxious to get out of here, so I will promise you we'll make it quick as possible. And so, with no other questions, you have okay.
But I just wanted to say that the LC number will be 5495, and it is identical to 5484. So I just wanted to state that now in case there's any
Okay.
confusion tomorrow.
Okay, thank you. And you, like I said, you can hold it up to the light. It's worth for. We're not going to sneak anything in on you. We've been through too much. With that, we're adjourned. Oh, I'm sorry. One more thing. I should have started the meeting with this. Bill Morey, who represents the car dealers, he's been an integral part of this committee for many years. He and Andrea lost their son this morning, Michael. So just keep that family in your prayers. Thank you, and thank you for being here.